Welcome to Military Justice and the Law, presented to you by Bulani Tseu. In this episode, I'll be talking about democratization of South Africa and its impact in the administration of military justice. On 2 February 1994, the last apartheid South Africa's president, Frederick Willem de Klerk, announced that the dates 26 April until the 28th of April in 1994 will be the days upon which South Africans of all races will have an opportunity to vote for the government that they want, not the forced government as it was the case under the apartheid regime. So on the 26th of April 1994, elections commenced. However, not everybody voted on that day, as that day was declared a day for special votes. In other words, soldiers, the hospitalized, and the aged, among others, are the people who voted on that particular day. So on the 27th of April 1994, the international community essentially witnessed the dawn of democracy in South Africa, because it was on that particular day that most South Africans who were eligible to voted. There were 19 political parties who participated in those elections. Amongst them is the African National Congress, the ANC, the Inkatha Freedom Party, as well as the National Party. And the party who won the elections is the ANC. And on the 10th of May 1994, the first democratically elected president, Nelson Mandela, was inaugurated. So the 27th of April 1994 is important for other reasons as well. Particularly, it is the day that the Constitution of the Republic of South Africa, Act 200 of 1993, came into existence. The interim constitution, that instrument had to be a game changer in that it assumed the status of supremacy when compared to other laws, unlike the apartheid times where parliament reigned supreme. In other words, under the apartheid regime, laws that were made by parliament were supreme. Courts were bound to follow those laws. It was not a duty of the courts to declare unlawful those laws. So Section 4 of the interim constitution made it clear that the interim constitution was a supreme law of the land, and any law, rule, or conduct that was inconsistent with it had to be declared invalid to the extent of that inconsistency. Within the context of the military, the interim constitution facilitated the integration process, in that Section 224 of the interim constitution made it clear that the new military will comprise of the members of the South African Defence Force, Umkhonto weSizwe members, APLA members, as well as the armies of the Transkei, Bophuthatswana, Venda, and Ciskei, the TP50 states. So, as I've mentioned in an earlier episode, that TP50 states were viewed by the apartheid government as independent countries. So the interim constitution dismantled that, in that the TP50 states were incorporated into South Africa as if they were never part of South Africa, because they were before the enactment of the Homelands and Citizenship Act. So equally so, these arms of services now, the Navy, Air Force, SAMS, together with South African Medical Corps, South African Medical Services, constituted the South African National Defence Force. So the South African Medical Services' name had to be changed in 1994 to South African Military Health Services. So those four arms of service exist up to this particular day as the arms of services. Within the administration of military justice, the interim constitution, had to basically bring about many other reforms. because Chapter 7 of the interim constitution made provision for the establishment of the Constitutional Court. Before that, there was no Constitutional Court in the apartheid South Africa. So the reason why the Constitutional Court came about, it was because apartheid was devastating in its execution, to the extent that human rights of the inhabitants, predominantly black, were regularly trampled upon. So the Constitutional Court was established in order for it to serve as a custodian or a guardian of these fundamental rights. So Chapter 3 of the interim constitution consisted of these fundamental rights. There were many such rights. For example, the right to life, the right to dignity, and not to be punished in a cruel or degrading manner. So these rights were to have an effect in some of the sentences that could be imposed, by courts, including the court-martial. As I've said, that court-martial, had authority to impose the death sentence on military accused who committed serious offenses, for example, rape, murder, and treason, among others. As well as there was a legislative provision in the Military Discipline Code, MDC, Section 4, which provided that a soldier who is guilty of endangering the safety of the SADF forces at the time, such a soldier could have been sentenced to death by firing squad. So with the constitution coming into effect now, one of the first decisions that the court had to deal with is a case of State versus Makwanyane and another. In that particular decision, what was at issue was the imposition of the death sentence, in that it was argued that the death sentence violated the right of the accused persons to life, to dignity, and not to be punished in a degrading manner. However, the proponents of the death sentence, being the state in that regard, argued that the death sentence was important in that it served as a deterrent to serious crimes. So in its decision, the Constitutional Court made it clear that, look, there are ways in which serious crimes, can be prevented other than basically executing people, either by hanging them from the gallows in the case of civilians. So when one takes it in the case of the military, it must follow that, it will have therefore been an issue to basically execute soldiers, by means of firing squad. So essentially, the Constitutional Court said that imprisonment for life, could well serve as a deterrent to serious crime as well. So there's no need for that. By doing that, the Constitutional Court declared the death penalty unconstitutional. So that had to have an effect as well in the military, because, as I've said, the Constitution was supreme. Equally so, the Constitutional Court was given a status of being the apex court in the Republic of South Africa. So, Section 4 of the Military Discipline Code had to basically be amended to remove or replace rather the death sentence that was prescribed with imprisonment for a period not exceeding 30 years. So in that way, soldiers could not be sentenced to death anymore. Court-martial had to sentence soldiers to basically imprisonment not exceeding 30 years. Part of the transitional requirements that had to take place before the democratization of South Africa was that, in the interest of legal certainty, laws that existed before South Africa attained democracy had to continue to exist until such laws are declared unconstitutional, by the Constitutional Court in particular. So that meant that the Defence Act 44 of 1957 will continue to exist. Equally so, that meant that, the court-martial system that was in place at the time will continue to be in existence. So court-martial will have to exist alongside other civilian courts. But courts-martial as well, there had to be courts that are still subjected, to the precedents that are set by the Constitutional Court. So essentially, in this episode, what I wanted to highlight is that for the first time in the history of South Africa, South Africans of all races had an opportunity to vote for the government that they want. And I've mentioned that the African National Congress is the party who won the elections and installed Nelson Mandela as its first democratically elected president. Also, I've mentioned that the warring parties, MK, APLA, SADF, and the TPVC armies, as they used to be enemies, were integrated under one umbrella known as South African National Defence Force, because the TPVC states were abolished because they were incorporated into a greater South Africa. So their armies, together now with these Liberation Armed Wings and SNDF, in constituting the SNDF had to be the single and only defense force in the Republic of South Africa. I've made mention of the fact that some of the sentences that were in existence before 27 April 1994 were brutal and cruel in nature. For example, the death sentence. This is therefore the reason why the then newly established Constitutional Court had to declare unconstitutional the death penalty. And that, although it did not deal specifically with the death penalty in the military context, had to have a spillover effects in the manner in which the military administered its own justice system, in the sense that the death sentence that was executed by firing squad ceased to be a punishment that could be imposed on soldiers. The legislative provision, being Section 4 of the MDC, which provide also for the imposition of the death penalty on members who endangered the safety of own forces, had to be amended, and that particular sentence was replaced with imprisonment for a period not exceeding 30 years. So that is all that I wanted to cover in this episode. Going forward now, basically, as the name interim constitution suggests, it means that it's a temporary measure for the final constitution that was to come. So in the next episode, I'll be discussing the birth of the final constitution and its impact in the demise of the court-martial system. So thank you for paying attention. Basically, I would like to appeal to all those who have not yet subscribed to the channel to do so. I thank you.